latest weather, traffic, and news updates online at 560theanswer.com. Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. Pagliacci Schumer took to the Senate floor to decry the Trump-Musk-Vought efforts at sci-fi voter suppression, algorithmic authoritarianism, and other fun phrases his speechwriters came up with in opposition to the SAVE Act or, frankly, any guardrails on election administration. And, doing basic things like removing people from the voting rolls who are ineligible to vote.
Voter purge database. The absolute last person Americans want combing through their personal data is Donald Trump. Letting Trump scrape through Americans' private data to purge them from voter rolls isn't just unpopular, it's illegal. Donald Trump, Elon Musk, Russell Vought wanted to plug in America's sensitive personal information, including Social Security information, into their shoddy database and have DOJ's algorithm decide who gets to vote. It's sci-fi voter suppression, authoritarianism by algorithm. Trump cares so little about Americans' freedom that he's trampling on their right to privacy just so he can take away their right to vote. For months, I've been saying this database was one of Trump's most sinister strategies for subverting our elections in November.
And what is he referencing? It was the subject of opinion that was handed down by a D.C. federal district court judge named Sparkle Suknanen, Biden appointee. And Jim Jordan explains what Schumer is referring to and the thrust of the decision offered by that D.C. federal district court judge.
The federal government has a list of people who are in the country on some kind of visa who are not citizens. States have lists of their residents who are on the voter registration rolls. So President Trump said with his executive order last year, match up the list and find out who's on the voter registration rolls who are participating in our elections, who should not be, because our law doesn't allow foreigners to vote in our elections. That is how common sense his executive order was. Simply let them match up lists. Now, a bunch of red states sent in their lists. Some blue states did. And what they find? Thousands of people were on the voter registration list in states that were not citizens. That's what he's trying to get at. And this judge says, no, somehow that tramples on rights. No, your decision tramples on common sense, for goodness sake. And that is so much of what's at stake here. Common sense versus the crazy decisions of the left and some of these judges.
And speaking of the decisions of judges, we've got several Supreme Court decisions that are pending before month's end when the Supreme Court's term ends, including on matters related to election integrity. For discussion on that topic, election integrity, those decisions, and others, including birthright citizenship, which also somewhat speaks to the underlying election integrity issue. Morgan Marietta joins us, professor for the Institute of American Civics at the University of Tennessee, Knoxville. Professor Marietta, thanks for joining us. Appreciate it.
Good morning, Dan. Good to be talking to you today. There's a whole lot happening at the court right now with major decisions maybe coming down tomorrow, maybe on Friday.
Yeah, well, they're T-minus 6 days, so they better start making with the decisions. On the matter of election integrity, obviously this issue hasn't risen, that was I just referenced, hasn't risen to the level of the high court, but there are other matters related to elections and the electoral process that have.
Yeah, there's a few things going on. There's one about mail-in ballots.
Yes.
And this one has a lot to do with that California election that just happened, where there was this tremendous delay, and nobody seems to be able to explain why it is that California can't count the votes in a day or two. And the real problem with that is that it creates a perception that there's fraud, even if there isn't fraud. it makes people think that there very well might be. And what's happening in the court right now is there's a case, Watson versus RNC, Republican National Committee, about what it means in the Constitution where it says that an election has to take place on a certain day. Does that mean that the votes have to be cast on that day? Can you have mail-in ballots that arrive later? And a lot of states now have shifted over to mostly mail-in ballots, and they let them come in a long time afterward. And again, it raises this perception that maybe the counting is fraudulent, or maybe they're ballot harvesting and sending in fraudulent votes. And the question is, can a state legislature rein that in? And I think the court's going to say yes, because the court's moving toward a more, I don't know if populist is the right word, but just sort of ordinary person's interpretation of language, really understanding that the Constitution is a contract between us and the government. And you can't just let people in power rewrite the contract and say that words mean something that they don't mean. So I think the court's going to say that an election day is an election day. And that means that if a state wants to say you can't allow ballots to come in a week late, then that makes sense.
Yeah, well, I mean, so as we know, elections are mainly state and local matters, and the Supreme Court is deferential to that construct. But is it your view that they'll say, well, you can do that if you want, but the states that are doing that, I mean, the states that can do it are doing that, and there's states that will not do it, like California, which enjoys the system they set up. You don't see the Supreme Court coming in and saying election day is election day, and you shall not collect ballots that have been cast or that are received after election day, for example.
Probably not. I think that federalism, meaning that states have a broad range to decide this sort of thing for themselves, that's pretty important. The Constitution does allow the Congress to make national rules, and they could do that. It might be a very good idea if they did do that. But I don't think a lot of people think that they have the political will to do that right now. So
right, I mean, so because I mean, to sort of ratify that states have this deference when it comes to administering elections, well, that's sort of already what we have. So now we're going to have the same. We'll basically have the same system we have. The states that want to ensure greater likelihood of election integrity, reduce the incidence of fraud or even the threat of it, are moving in that direction, or will continue moving in that direction. The states that don't want it won't want it. But the problem, of course, is that necessarily implicates national elections, like for President of the United States. And, you know, so there is potentially an inflect or an angle in for the Supreme Court should they decide to take it.
Right. Federal law on this can actually preempt even state law, potentially. So we will see if the Congress is willing to step in and make a national standard. And that I think the court will allow them to do.
The case that probably is going to be most poured over and potentially the biggest powder keg is the birthright citizenship case. Because if the Supreme Court changes sort of the more or less the precedential holding that in terms of what the 14th, that subject to the laws thereof, what that phrase in the 14th Amendment means, to suggest that just being here at your birth does not automatically confer citizenship. That is going to be terribly impactful and highly controversial. I think there's a pretty strong argument in that direction to be made. Where do you see the court on that issue?
I'm afraid that the court probably will not make the right decision on this one.
Really?
You never know. They could gain courage, but I'm afraid that they really won't. It's really fascinating timing with the Declaration of Independence 250th anniversary coming up, because the whole crux of the case is whether you really take the Declaration seriously. The Declaration of Independence is a statement that we are a sovereign country, that we the people decide these very important things. And we broke with the old English common law that the court cites on this. And we decide who we are. The whole idea of citizenship is that a citizen, if we take in a new citizen, It's someone we're saying has equal share in elections and voting and deciding the future of the country as everyone else. It's actually a much more important thing than people are giving it credit for. And the whole idea of this controversy is deciding if there is such a thing as citizenship without consent, which there is not under our Constitution or under the Declaration. And the 14th Amendment doesn't say that there is. Obviously, Dan, you couldn't just say you were a French citizen. I mean, you wouldn't want to, but you couldn't just demand to say that you can vote in French elections. And everybody would say, yeah, of course, the French people have to consent to that.
Right.
And the same is true of us. We're a universal nation, and we're incredibly open and tolerant compared to almost anywhere else in the world. But we still hold the decision of to whom we consent to become a citizen. And there's no such thing as citizenship without consent. And that's what the 14th Amendment says. People read it and really aren't honest about the reading. They say it says that everyone born in the United States is a citizen, and that's true, but there's a qualifier. And the qualifier was put in for a very specific reason at that time that says you also have to be subject to the jurisdiction of the United States. And that's a really simple thing. It means there's a mutual agreement. It means that somebody says, yes, I want to be a citizen and live under the rule of the United States. And the United States says, yes, we agree that you are one of us and are living under our rules. And that clearly isn't the case with anyone who comes here illegally, or even anyone who's here just temporarily as a birthright tourist. And people leave out that whole part. A lot of it is about birthright tourism. It's about wealthy Chinese citizens who come here to have a child and then go back to establish citizenship. And they have not been, we could allow that if we want, but we can say no to it. And that's really what this whole case is about whether we have maintained our sovereignty. And no one at the time of the 14th Amendment, when that crucially important amendment, which was making sure that the recently freed slaves and all of their descendants were citizens of the United States. And that was an incredibly important thing to say. And it had nothing to do with allowing future unlimited universal birthright citizenship. And no one at the time thought they were agreeing to that, and they didn't agree to that. And that's simply not what it means. And the question in the current moment is whether the Supreme Court will have the courage to say so. I'm afraid not, for a few different reasons that we could talk about. But
well, I mean,
I have a feeling they're going to rule the wrong way.
Well, who do you think is going to blink on the matter? But I mean, this is a court that had the political courage to overturn Roe, which was terrible law. So why wouldn't they have the political courage to do this? Who's the problem, do you think?
Well, it's funny you mentioned Roe, because that was a similar situation. For 50 years, the court said something that blatantly was not true.
Right.
Which is that there was this manufactured, invented sort of imaginary right of privacy. And that imaginary right applied to abortion, and just sort of made this up out of whole cloth. But it took a tremendous amount of courage for the court to say that, no, what the Constitution really says is, again, federalism, that states can decide this on their own. That's what the Constitution says, and they finally said it. But you remember how much vitriol there was, and how much bad feeling, and how much real willingness to buck the establishment and take a lot of insult and even violent threat toward themselves that it took for the justices to do that. This one, I think, is even worse, because the whole idea of immigration is the core of the whole Trumpist argument that Trump started his campaign in 2015 about immigration. It's considered this core dispute on the left just about decency, that you're an indecent person if you decide the other thing. So if you say the truth on this one, that this is something that is up to the Congress, it's up to the citizens of the United States to decide future citizens, and that's what the 14th says, the justices or professors or public figures will be considered to be a very bad and indecent person by a lot of people. So I don't think Roberts has the courage for that. I'm guessing Barrett doesn't have the courage for that. Not sure Gorsuch does either. I'm really not sure. You couldn't quite tell at the arguments to the court who was coming down where, but there seemed to be a great deal of skepticism. And there was a lot of acceptance. I don't want to say it's all lack of courage. I want to say something else, that when you go through the study in college and especially law school about constitutional law, they tell you a lot of things that just simply aren't true. And they get stuck in your head. And one of them is about the Wong Kim art case that you
Yes,
probably
yeah, we've
read
talked
and heard
about,
about,
yeah.
people talk about.
Hmm.
And that one is taught as if the Supreme Court said in the late 1800s that universal birthright citizenship is what the 14th Amendment says. That is not true at all.
Right.
I recommend reading that case, but nobody does because it's really long and archaic. But that's not what it said. It's really sort of shocking. I was taught that, and then I finally read the case myself and was pretty angry about how it had been misrepresented. The case is about a guy who's the contemporary equivalent of a green card holder. His parents were permanent legal residents from China, and they weren't citizens, but they were permanent legal residents. And the question in front of the court was whether someone who was the child of a permanent legal resident was an automatic birthright citizenship. And the answer is yes, for the reason that we said, that the parents had
Conferred.
stated,
Yeah.
right, that's right, it was consent. The parents had stated that they wanted to live here permanently, and the government had allowed it. And if that's the case, then yes, your kids are definitely American citizens. But it had nothing to do with people who are here illegally. And it's presented that way. But that's not what the court said, and it's not what it meant. There's a much better case, by the way. It's called Elk v. Wilkins. This is an 1880s case. It's much closer to the time period of the 14th Amendment. It was about 20 years afterward. And the question here was whether an American Indian, a Native American, a guy named John Elk, he was suing for similar arguments that he should be a birthright citizen because, of course, he was born here in the United States. And what the court said, for exactly the reason that I've been saying, is that no, he wasn't, because under the law of that time, someone who was American Indian was under the sovereignty of their tribe, and they were not subject to the jurisdiction of the United States. And the United States had not accepted them as a citizen, and they had not stated that they were permanent residents under our sovereignty. So obviously they were not birthright citizens under the 14th. And that'll change in the 1920s when the Congress decided, and this is the meaning of subject to the jurisdiction, the Congress decided that Native Americans are subject to the jurisdiction, and then it all changed. But the court was right in Elk v. Wilkins, and people misrepresent what they said in Wong Kim Ark. So, but I'm afraid that got stuck in the head of a lot of the justices.
Yeah, there's been a lot of scholarship written on this, including recently. Probably some people polished off old term papers and reposted them because of this case. So, I mean, it's hard for me to believe that that at that level with those intellects, maybe excluding Ketanji Brown Jackson, that they're unaware of the arguments and the case history and the and the actual facts in those cases, including the basis of those holdings. So I don't know. I think if they don't do it, it's going to be much more about political courage and basically the integrity of their jurisprudence, and less so about, oh gosh, I just had this in my head from Yale. I don't know.
Well, what I mean by that is, for scholars, it's really hard to publicly state that everybody else is wrong. And
they would hardly be alone. I mean, they'd hardly be alone. So let me get.
Well, it takes more courage than you might think.
Obviously, right. Well, that's why we call it.
We're going to see, Dan. That's why they do. I'm even a little optimistic that they might.
Well, that's why it's one of the cardinal virtues. Yes, I know. It's
that's right. Easy. No, courage is the virtue, because everything else follows from that.
Yes.
But you never know. They have had time to rethink it and go through it. And they might have had some discussions. And, the courage is contagious. So if one of them did it, maybe the other ones will do it. I'm holding out a bit of hope.
Yeah.
Because it is actually about whether we're going to read the Constitution in an original way or not. And sometimes that takes more courage than other times.
Yeah, we'll I'll send those justices a copy of Abolition of Man in advance of their rendering. Real quick, though, the trans athlete case, that's another hot button issue. Trump has made it particularly political, one of his political priorities in advance of the midterms, that banning men from participating in girls' sports. Where do you think that goes?
That one, I think they're going to rule the right way. And the right way on that is to recognize that a big part of what the court does, and this is just really not as well understood as it ought to be, but it's a fascinating thing. A big part of what they do is make rulings on reality. on the social facts of the world, meaning that if we're in dispute about an important reality, and a classic case you mentioned about Roe is about abortion, but is a fetus. What is a fetus in reality? Is it a person that's a rights holder like you and me, or is it not? And the right thinks that a fetus is a person, a rights holder, and the left thinks that a fetus is a clump of cells. And you have to decide. You can't get out of that decision. You have to decide on these facts of the world. And either the Supreme Court has to decide itself, or it has to do what's often the right thing, which is to let states decide it in a federalist world, what I call the federalism of facts. And that's what this is about. The holding in the recent case in Dobbs, overturning Roe, is that states can decide for themselves. Mm-hmm. So we live in a nation where a fetus can be a person in Tennessee, but is not a person in California. And maybe that's what the Constitution allows us to do. And the same thing is true here. The court is finally addressing the core question of someone who is a trans woman. Is that a woman or a man? Someone who was born male but insists to the world that they're female. Does the state have to agree with them? Is it the law of the land that if a person says, I was born male, but I am a woman, the state has to say, yes, I agree with you? Or can a state, and this is what West Virginia is doing, is saying that, well, you can say that and you can live that way, but we don't agree. So we don't agree that a trans woman is a woman, and we're not going to let them participate in sports with this unfair advantage. And I think the court's going to say the right thing on this. I think they're going to say that there is a federalism of facts. A state can actually decide this because it's disputed in our society. We don't agree fundamentally. Some things are so agreed upon as facts that a state couldn't go its own way on it. But something that's a major social controversy, yes, a state can decide what fact they recognize. And I think that's exactly what the Supreme Court is going to say.
Morgan Marietta is a professor for the Institute of American Civics at the University of Tennessee at Knoxville. Professor Marietta, thank you for joining us as always. Appreciate it.
Dan, thanks so much. Take care.
Take care now. And he joined us in the alphawealthgroup.com answer line.
There's only one radio show in Chicago talking about today's biggest stories and telling you what they really mean. That show is this one, Chicago's Morning Answer on AM 560, The Answer.
Platform safety is critical at your commercial and industrial facility. Keeping people safe